USCIS changes the medical examination requirement again.
Yeah.
And it is for refiling of a case. And in summary, if you're refiling your case, don't use the old form because they will not accept it.
Yeah.
We're going to detail that for you. I'm Sam Shihab with the law firm of Shihab Burke.
Brian Burke from Shihab Burke right here.
We're immigration attorneys who practice immigration law throughout the U.S., throughout the world, focus on employment immigration and family immigration. And today we're going to talk about USCIS coming out and saying this open-ended approval to use and reuse the medical examination of the Biden era has ended.
Yeah, I mean, I think it's a good opportunity for us to talk about sort of like the growing liberality that we had with the medical examination requirements and this sort of thing that sort of bodes as perhaps shrinking them and tightening them up a little bit.
Spend a minute on what's the medical examination and why we have it, Brian.
Well, medical examination is a done on Form I-693 by a doctor approved by USCIS to do examinations for immigration purposes. There are certain requirements of the law that if you have certain medical conditions, you can be called inadmissible under the law. And basically that doctor's job is to give you a poke and make sure that you can meet the medical requirements for immigration to the United States.
That you are if you meet the medical requirement, you are admissible, and therefore you overcome one of the grounds of inadmissibility.
Of the many long list, yes. Sir.
Yes, and so therefore every green card issued in the United States must have a medical examination, whether you are abroad or you are in the U.S., to confirm that you are a physically and mentally fit person to become a member of the United States of America's society, and that called the medical examination. Now, let's go through a history of that during the Biden era.
So, you know, we just saw sort of the requirements for medical examination get really sort of broad. You know, if we travel back, you know, let's say historically, you used to require, at the time you file your I-45, you should file with a medical examination, right? And let's see, during the Biden administration, they said, you can file at a later time. Let's see, one of the things they did during the Biden administration, they originally had a rule called the 60-day rule that said basically you got to send that medical exam to us within 60 days of the doctor signing off on it.
No.
What was it?
Sorry.
So
you're right on the money, but I just read it. That's why I'm kind of a little bit fresh on it.
You got more money than me.
A little bit fresher on that one. So the physician must sign the form, the old rule, within 60 days of conducting the first test. So if there's 5 tests that he has to do, the date the first test is done, that date, and the date the form is signed cannot be more than 60 days apart. That rule is abolished. That rule is gone. In 2023, the Biden administration said this rule is confusing. It makes no sense because you guys probably got confused explaining it to you, and it does not exist. Today, June 11, 2025, this rule does not exist. Now, who knows what the Trump administration will do next with this medical examination? And that's why I stated the date, so people watching this YouTube understand that we are speaking as of June 11, 2025.
Yeah, and the standard right now, June 11th, 2025, is if you submit a medical examination with a shiny new I-45 application that you file, it's good for the length of that application, however long it takes USCIS to approve it. That's that. It does no rules about expiration after 2 years, which used to cause problems for everybody, generating medical exam RFEs for long pending cases like that. So the policy today is just kind of a little innocuous one. They came back to clarify that, hey, we are going to, if you have a case that's withdrawn or denied in I-45, right? Well, you can't use that medical exam again for a subsequent case. If you're going to file a new I-45, you have to send us with that case a new medical exam because, and to quote the policy here, I will
in the interest of public safety, and the prior rule does not serve, blah, blah, blah. It's some ridiculous language.
Yeah, they said,
go ahead and read it.
The old public policy, as was expressed in April 20, the widest version that we got as of April 4th, 2024, they say that it is overly broad. It could potentially threaten public health in the United States. By limiting the validity period to only the current immigration benefit, application, or request, we ensure that aliens get timely and proper medical examinations and treatment, which safeguards public health.
Yes.
Yes.
Now, the new rule is you need to go back to the doctor and get another form and then submit it with a refiling of an adjustment. Now, in this, when do you have the scenario? If there is a denial, a technical denial,
Sure.
They happen sometime. You didn't mark this box. The check was, well, that would be a rejection if there's anything with payment. And
Yeah,
the
that's true.
rejection, we're going to talk about that later. But let's assume there is a missing something, page missing in the deny case, or there's an error. Now, you file a motion to reopen and to reconsider, and if they take it back, you're good.
It should be, yeah.
You're fine.
Yeah.
Okay? But if it's rejected, then you have to prepare a new set of forms, and then a new check, and a new medical, then you cannot use the same one.
Yeah.
And if you're doing a double adjustments,
Yeah.
you file an adjustment, an EB2, now a year later you want to do an EB3,
You're gonna
you
need-
cannot use the same
For
form.
the public health, you give them a new medical exam from when the time you file the new case. Yeah.
Here's the silly thing, however. You can go back to the same doctor as of today, June 11, 2025, and I put that date because I'm suspecting that the 60-day rule is going to get reinstated again. And therefore, you need to make sure on the day you do this that you check the current law with your attorney.
Yeah.
But today, you can go back to the doctor and say, use the old tests and use the most recent form and regenerate the form for me again. And if the doctor agrees, hopefully at a reduced fee, because you're not going to have to do the test because the 60-day rule does not exist. You can use tests that are 8 months old, 9 months old for the doctor, if the doctor is comfortable of producing the form signed today for a test that was done 5 months ago. That's up to his or her discretion. But if they can do that, you could possibly avoid having to pay the $1,000 one more time or the $800 one more time. And that's the workaround today, June 11, 2025. I expect the 60-day rule to be reinstated sometime soon.
I don't know whether I guarantee the 60-day rule, but I perceive a tightening of medical examination requirements.
What is the policy and what public purpose does it serve outside the jumbo mumbo that we read? Something that really makes sense. What is it, Brian? Because I don't see it.
Oh, the medical exam. So
this new policy.
Well, I'll give you a take for adjustment of status for anybody who's already here in the United States filing adjustment of status. Let's say you talk to somebody who's been on an H-1B visa for the past 15 years, right? You didn't require a medical examination to get that H-1B visa. You've been within the U.S. populace for the last 15 years. If there's a...
So the answer is absolutely none.
Yeah.
Thank you. That's what I wanted to hear.
I wasn't quite sure that was your getting at, but yeah.
We are at 6:11 here Eastern time, and we promise to get to people's questions. Now, guys, ask your questions. We're going to answer your questions, all of them here live. So I'm encouraging you to ask questions, and you, as Brian is putting this on the right screen.
Well, speaking of putting things on the screen, Sam, immigrationquestions.us.
But I want to clarify something. I think people think that because we're using immigrationquestions.us, that we're not answering questions live. We're going to answer all your questions live that are coming in. And those who have the foresight to ask questions during the week for us, and we have plenty, what we're going to do for these people is answer the good ones live and reply to those people with answers as a courtesy to them, so they're all are getting the attention they deserve by coming and thinking in advance. We are encouraging people to go there and ask their questions because that allows us time to look at them and address them more completely. But your live questions are equally as important, and we want to get them answered. So I don't know if there's any live questions yet, Brian.
No, but I definitely have a good one from immigrationquestions.us.
Let's go there as we get people to put their questions in.
Let's see what we got here. So my employment EAD expires 3/2026. Can I apply for renewal now before 6-month expiry limit so I continue working before it expires? What are the current processing to get new employment EAD card time frames? So I guess let's start with, can we agree with, generally speaking, there's a 6-month expectation. Don't file your EAD extension more than 6 months out. USCIS, if you already have something and they're irritated by a request, will say, you already have one. Why are you asking for this? So agree on that. there's sort of limited circumstances where sometimes you can convince them to issue you a new EAD, like an H4 EAD scenario. If you're filing an H4 EAD with your spouse's H1B extension, and even though you might have more than 6 months, oftentimes they'll process those cases. But the processing times. So I guess, well, maybe I got to deal with the most important question there, Sam. So I can keep working. The question says, can I continue working before it expires? I think they mean continue working after it expires.
Well, it's the same thing. It's you're and the writer is getting to the same question.
Okay, so there are a bunch of different categories of EADs, and some of them are subject to different automatic extension rules. And for anybody looking to sort of learn about the rules for automatic extension,
so I'm gonna get to the trying to help you out here. So what about an adjustment of status case based on employment-based? Is there an automatic extension on that one?
If you file it timely before your current EAD expires, yes.
For how long? 180 days?
It is.
It's more than that.
I believe it's 540 days now. There was talk of, there it is, 540 days. So
okay, excellent.
I'm going to put a link in the chat to the USCIS webpage about automatic extension of EADs, where it kind of gives you the sort of user's guide to automatic extension of EADs.
Yeah.
But the rules are different depending upon certain categories. For example, H4 EADs have the problem that you're not eligible for automatic extension unless you have a valid I-94. Not a pending extension, but a valid I-94.
For the duration.
Yeah, for the duration. Yeah, exactly. So,
which I hate to say it, but it makes sense because they cannot give you EAD beyond your valid duration.
Yeah, but okay, so you're.
I don't like the rule, but it's unfortunate.
But you have your H4 extension is going out with your spouse's H1B extension, and you're going to put an H4 EAD extension that same. So if they're going to approve your spouse's H, they're going to approve your H4, and they're going to approve your H4 EAD. Shouldn't they? I mean, as long as you have a passable case, shouldn't they extend you the benefit of that employment authorization?
I don't like the rule, but I can give you the counter argument.
Please.
And the counter argument is then there will be an abuse of filing these cases to get work authorization, and then by the time the government gets to it, 5-6 months later, somebody's continued to work for that time. It's the concern.
Okay.
I'm just giving you the thinking.
I don't buy
on
it.
the other
I
side.
don't like it. I don't believe it. I'm against that concern.
No, you're the immigration lawyer. You shouldn't like it.
Well, you are too.
Yeah.
Not in this scenario, I guess.
I'm putting the hat on of the USCIS. But let's take the next question here and ask people to drop your questions if you have them, and we will get to them.
Yeah, I mean, we'll take them through immigration-questions.us, but we're also happy to take them through the live chat here because that's fun too.
Yeah.
So let's see here. So there's what we got from immigration-questions.us. And it's a pretty good one too. And this question is from Phil.
I'm currently
There it is.
I'm currently on E2 visa with a recently approved perm. I am not current, hence my employer can only file the I-140 at this stage. Okay, understandable. Is it okay to travel outside the U.S. while the I-140 is pending? How about when it gets approved? Excellent question. I think I've had probably the identical scenario.
Yeah, you've mentioned this before. At the border of Canada, I think.
At the border of Canada, and they would not issue.
Yeah.
They would not issue the visa because pending I-140, we had to withdraw the I-140 to get the visa and then refile the I-140. Unfortunately, 6 months later, because we don't want to do an immigrant and you don't circumvent the
I'm going to talk about why. So
yes, go ahead.
E2 visas come with I guess I sometimes call it a pure non-immigrant intent requirement. So meaning you can't intend to immigrate to the United States while you're on an E2 visa. Now, practically speaking, this person can file a permanent I-140 because sometimes circumstances change after you enter the country. But if you come to the U.S. border or ask for an immigration benefit from USCIS and you're on E2 status or asking for E2 status, and they see that you have a pending or approved I-140, they can come back and say, wait a minute, your E2 status does not allow you to intend to immigrate, and that I-140 says exactly the opposite, and that's hence your scenario where somebody came to the border asking for E2 status, they said, wait, you have an I-140 approval, no go. That's, of course, contrasts with H's and L's, with good examples of non-immigrant visas that allow you to intend to immigrate. No problem. You can walk into the consulate.
So there's clearly the risk, even if the I-140 is not approved, because the filing of the I-140, although, in my opinion, is really not a good policy. The filing of the I-140 shows immigrant intent, but really it doesn't, because there's no signature of that applicant on that I-140 petition.
Unless it's a self-sponsored one.
Well, yeah, you're talking about lit perm.
I'll give you that one. Yeah.
So in this case, it really doesn't make sense, but that's how they read it, and we're not going to change how they read it. So be aware, if the perm is valid for 6 months, go on your trip, come back. The perm alone is not an immigrant intent, that's well established.
Yep.
Go on your trip, come back, and file this 2 weeks before the perm expires, in my opinion, and you should be in good shape.
Yeah. Travel first, get that long E2 I-94 because...
Get out of your system, get the E2 renewed if you need to.
Yeah.
Get all those things.
My worry for somebody like this is my I-140 priority date going to become current before my E2 status runs out. That's just one of the reasons why you might consider traveling.
Yeah.
But again, you have to really worry about questions of immigrant intent on that for sure.
Yeah.
So another question here from good old immigrationquestions.us. Ooh, it's a long one. And that's one of the best parts of immigrationquestions.us, Sam. It's called, we can get long questions here and they don't get broken up. So it's going to take me a moment as I sort of put it up here in parts, but that's part of the fun of immigrationquestions.us. So let's see what we got here. Sort of the facts here.
All right, so as you prepare the next one, I'll do this one.
That's
here.
fair.
A long-time TN holder with the same employer who is now sponsoring me for a green card. This is really interesting also because...
Yeah, a lot like the E2 scenario.
I-140 for new position promotion was approved earlier this year, now waiting to file I-485. 2 questions. And question number 1...
looks like it may be too long to fit in our box here. Let me see here. Let me see if I knock that off. There we go. Here we are.
On 2 occasions, CBP made an error in my I-94 record, one time making class of entry as B1 and the other time B2. Company's attorney was notified of each occasion and did not initiate any action with CBP.
And the little part that got cut off was this big question: is will this be an issue during adjustment of status?
Well, I mean, I don't like it. I don't like that that you did not work with your attorney to resolve this. This is a big, in my opinion, it's a big deal, Brian.
Yeah, I mean, I'm going to go beyond big deal and explain exactly why.
And I would say it might be not too late. It might be difficult, but you gotta resolve that.
Yeah, I mean, the bottom line is this is a question of, were you using your visa right? And the official government record is going to record this person one time on B1, one time B2, and your I-45 application is going to say when you were working. And if, let's say, a astute government attorney goes back and says, well, this time says you are on B1, and it also says you're working inside the United States, you have a problem because you worked without authorization. And this raises all sorts of fun questions like, well, yeah, one option is to fix it. You have to try to fix it. And that might be something you can do. It might raise some interesting INA 245K scenarios as well, which might salvage the entire thing.
It all depends on the duration, Brian. If this duration is years, it could be not salvageable.
But
that's number one.
That's on a prior visit. These are all. I think these are all on prior visits to the United States.
That's even worse.
In what sense?
If the stay is a year and a half beyond the B1, which is 6 months.
Oh, I see. You're okay. So you are bringing up the scenario. They gave somebody a B1 entry. And then they said tra-la-la because they didn't notice it, and then suddenly they overstayed it. Okay, I see what you're saying.
CBP may take the position, I hope not, that we didn't give him the wrong visa.
Yeah.
No, we gave him B1.
You're Canadian. We gave you B.
We gave you a B visa. This is what we intended to give you all along.
Yeah.
We've seen that before.
Yeah.
Okay, this case falls in the category that really need to be looked at carefully, so we can help you, or the attorney can help you resolve this. So quick answer to this question: yes, this is a concern. It needs to be carefully addressed. Now, I may not have enough information, and there could be some good information that can be provided that I would say, oh yeah, I get it now. It's not a big deal, but I don't have that information yet.
So you and I are looking at this issue differently then. So you are looking at basically the scenario is you come to the border, you get B1 or B2 I-94, and then you stay for they only give you 6 months on a B1 or B2.
Now you have a 994 for TN for 3 years. You stay 2 years, for example.
Yeah, exactly. So somebody accidentally, even though the I-94 officially on the record is for 6 months, you stay 2 or 3 years. You have an overstay scenario. When you traveled back, you activated the bar, right? Now I was thinking about
I didn't want to say that word, but
well, you might have.
I don't want this guy not to sue.
Hypothetically, again, we don't have all the details here. This is the sort of thing we could literally talk to somebody about for an hour with.
Sure.
But I was thinking about it more from the unauthorized employment scenario.
Yeah.
Basically, you enter on B1 or B2, and you're working, which clearly you were if you thought you were on TN.
Yes.
Yeah.
There's part 2, but let's see if there's any question got dropped here, because I am interested in on the chat here.
I don't see any right now. Let me just do a refresh. And,
okay.
Yeah.
All right.
I don't see any, so I'm going to keep on going back to Alex's question, part 2 of this question here.
Okay, sounds good.
And maybe we should have read part 2 because there could have been more pertinent information there. But let's see what Alex has given us in part 2. Primary apps. Let me see. Oops. Yeah, I got to cut it down a little bit. That's one of the downsides of these lovely long questions on. Let me see here. There we are.
All right. So, have you seen any cases where during adjustment status, USCIS questioned immigrant intent for past TN renewals, re-entries in hindsight will be long past the 90-day rule when I-45 is filed and was never questioned on immigrant intent?
Immigrant intent by USCIS during past
So
TN
assuming
renewals.
question number 1 is not an issue, because there's 2 questions.
The B stuff, yeah.
So we're assuming question number 1 is not an issue. So with that assumption, we're answering question number 2. Okay? So I don't want to complicate things.
Okay.
Now, I have not seen an officer questioning immigrant intent in this scenario, no.
Yeah. So maybe I'll talk about the 90-day rule. So briefly, the 90-day rule is sort of an idea that is not even on USCIS policy anymore, that says if you do something contrary to your non-immigrant status within 90 days of entry, we can consider that evidence of immigration fraud, more or less. And so this would manifest in this scenario where somebody entering on a TN visa, then if you filed an I-45 within 90 days, they could say that's evidence of immigration fraud. Now, one thing I would say is the 90-day rule is gone. It is no longer on the USCIS policy handbook. But
what about the 60 days? Was it 60 days?
And it was 60 days at some point as well. Again, changing policy during the first Trump administration, as I recall.
And it's removed.
And but the way I always explain it to people is, the officers that have done this job, they've done it a long time, and their brain is not a policy handbook that you can just kind of delete things out of. And I always, say, keep that in the back of your mind when you're making your immigration filings, essentially.
So you have to assume it exists.
Yeah.
And therefore, although legally it's not there, emotionally, psychologically it's there.
Yeah, that's a good way to put it.
And if you file your adjustment within 90 days of entry on TN, there might be a presumption by the officer that you have entered to immigrate on a TN visa that has a non-immigrant intent. And if that happened and it's too late, if you haven't filed your adjustment, I would just cross the 90 days to avoid dealing with it. But if it happened already, then you need to work with your attorney to prepare a polite but a well-drafted response that this policy is no longer in place.
Yeah, you had mentioned, not really recalling ever being questioned. Was that correct on the concept of the 90-day rule or immigrant intent like that?
On immigrant intent in general, not the 90-day rule. Clearly, the 60-day or the 90 depends on what time it was. Yeah. Trump 1.0 was 90 days. Every time before that,
60 days.
It was 60 days for a long time, and then during Biden it was 60 days, and then it was removed.
Yeah.
Right? Are you sure about that?
I know. The 90-day rule. It used to be. It's actually, as I recall, a Department of State thing. The Department of State, I believe, that still has it in the Foreign Affairs Manual. Okay. So they can basically.
So we assume it exists. Let's assume it exists.
It's out there. It's a tool. It's a tool for the government for sure.
Yeah.
It's not a hard and fast rule, I guess.
Okay. Yeah. All right. Sounds good. So, I guess it's a presumption. That's number one.
Yeah.
And I always talk about the dual intent. And there's a lot deeper analysis. I'm going to stay out of that on the concept of dual intent, to be honest with you. But what you need to remember that you could enter the U.S. on a TN visa with intent to depart per your TN visa requirement, and that's what we call a short-term intent. With the longer-term intent of immigrating to the United States pursuant to an adjustment, with the understanding that you will respect the short-term intent and its requirement to depart at the conclusion of your TN status.
Yeah.
And that's how we typically try to reconcile that.
Yeah, that's a fair answer there.
Yeah.
But any cases where I've encountered where people are kind of may have run afoul of the 90-day rule, I can't recall ever being seriously questioned, on the subject there. Yeah.
We not going to go into all the questions on immigrationquestions.us, except I probably touch on one or two. There's probably one more question. When can I travel internationally while my green card is pending? That's probably a good one. Now, a green card pending, I mean a pending I-45 adjustment of status.
That's a fair way to put it.
Okay. Yeah. Now, so there are typically, if you leave the United States while the I-45 is pending, and if you do not have an advanced parole, and if you're not on an H1 or L visa, or H4 or L2, if you have not been on you don't have an advanced parole, H1B, H4, L1 or L2, you have abandoned your application will be denied. And therefore, to travel, you must have a valid advanced parole and return during that period. You must have an H1B approved.
Yeah, or one of those,
and return during that time. Or the other visas. That gets us to 628. Do you want to take one more question?
I'll take one more question from one of these ones that somebody had sort of sent us in the middle of time. What protections are available if an immigrant is exploited by their employer? And I would tell you, Sam, I end up actually taking a fair amount of consultations, on this subject.
Well, do you have 20 minutes? Because that's a very important question, but it's also a complicated one. And I will begin by saying you have to define what is exploitation.
Yes, it's true,
Because there is a lot of things that the employer expects people to do that is not exploitation, but the employee thinks it's exploitation. And that's where the rub, we step outside immigration law to know whether the employer, but I have seen employers do crazy things. And I have good clients that came to me many, many years ago, and when I reviewed their practices, I told them, you absolutely cannot have foreign workers working for you because you will be so much subject to exposure by the Department of Labor. And I advise clients to not do these things. They got to abandon everything. But let's assume we're not going to talk about what is exploitation. And let's assume there has been an exploitation. What to do?
Well, I mean, I think the average person really kind of needs to talk to an attorney just to figure out, the rules for these are really sort of fine, and I have sometimes I talk to somebody and say, I don't think that's a violation of the rules in my honest estimation. But the bottom line is you can complain to the government about if you are being treated improperly pursuant to the terms.
So the Department of Labor has processes in place. USCIS has processes in place, and the state that you're in has laws in place to protect employer exploitation, and the federal government has processes and laws in place. You probably need to have a consultation with an immigration attorney and a labor attorney to look into the details of these.
Yeah, because I actually talked to somebody. I mean, the issues that come up with that sort of scenario, it's if you have one immigration issue, if you're not being tried to read on the immigration laws in your current employment, but if you have to sort of make your way in the world immigration-wise, otherwise, it creates all sorts of new immigration challenges for you. It's fun times, that's for sure.
Yeah.
Yeah.
All right, wonderful. Thank you guys for listening to us. We'll come back Monday